Welcome to EUPrivacyForAll, Session 5 on GDPR finally published, Article 48, Transfers or Disclosures not authorized by Union law. Article 43A, largely debated during the trilogue negotiations, was renumbered Article 48 on transfers or disclosures not authorized by Union law. It lays down that any judgment of a court or tribunal and any decision of an administrative authority of a third country requiring a controller or processor to transfer or disclose personal data may only be recognized or enforceable in any manner if based on an international agreement, such as a Mutual Legal Assistance Treaty, an MLAT, in force between the requesting third country and the Union or a member state, without prejudice to other grounds for transfer pursuant to this chapter. As set in Recital 115, the principle laid down in Article 48 is recalled, and additionally it is made clear that transfers should only be allowed where the conditions of this regulation for a transfer to third countries are met, that is to say, beyond international agreements, the usage of the tools provided for transferring data externally shall be used. In Recital 116, it is also made clear that the increased risk on the ability for a natural person to exercise his or her data protection rights should trigger some additional guarantees. That is to say, for supervisory authorities, a way to pursue complaints or conduct investigations. There is therefore a need to promote closer cooperation among data protection supervisory authorities to help them exchange information and carry out investigations with their international counterparts. The Directive 95/46 does not lay down any specific provision on transfers or disclosures not authorized by Union law, but in Article 2b, 11, 14 and 17, reference is made to disclosure of data, and Article 26 and 25 refer to general provisions regarding transfers. What should accountable data controllers or processors get prepared for? First, they should know that international agreements such as MLATs, Mutual Legal Assistance Treaties, are necessary to have any judgment of a court or tribunal and any decision of an administrative authority of a third country being recognized in EU. A controller or processor can legally transfer or disclose personal data only under the condition that, first, such an international agreement will be used, and second, the transfer will be implemented in the frame of the GDPR general grounds for transferring data. Closer cooperation should be resulting and promoted between data protection supervisory authorities to exchange information and carry out investigations with their international counterparts. The caveat shall be shared, though. Such valid and efficient agreements should be into force between the requesting third country and the Union or a member state. That is to say, will new MLATs be proposed, as overall their efficiency could be questioned today, and will EU countries be using international agreements?